Welcome to the State of Accessibility podcast from TPGI on LinkedIn Live. I am Mark Miller, and this is my co-host, Dr. David Sloan, Chief Accessibility Officer for TPGI, co-author of What Every Engineer Should Know About Digital Accessibility, and a user research and accessibility strategy specialist.
And Mark is the Sales Director for TPGI and a member of W3C's Web Accessibility Initiative Accessibility Maturity Model Task Force. Mark, this is the 8th podcast we've done so far. I can't believe we've done so many.
That's pretty good. In the last one, we were live from CSUN, which was a whole lot of fun. We had a lot of people join us. But this one, David, we're going to focus on a really important topic, one of the kind of many things that people are focused on and thinking about currently, and that is Title II of the ADA, and the fact that we're approaching 1 year before the first deadline for conforming with Title II, with a Title II rule in the web content and mobile app accessibility. So it's kind of this, I don't know, reverse anniversary. We've got a year ahead of us to think about the web content and mobile app accessibility. So today we're going to talk more about that rule, what it means for the public, entities in the US, their vendors, and of course, for people with disabilities.
Yes, I was just going to say, what is that word where it's like the opposite of anniversary, 1 year before something's going to happen?
I was trying to think of it like it feels like anniversary, but I don't want to say
anyone listening with suggestions for what that word should be,
the word is
know.
a phrase, and the phrase is you got 1 year.
Yes.
That's it. So let's start with if you want, let's start with a quick recap of ADA Title II, what it requires, and who it applies to.
Sure. So yeah, ADA, the Title II of ADA applies to programs and services provided by state and local governments in the United States, and that could include public education, K through 12, higher education, public transportation, voting services, healthcare, social services, courts, emergency services. There are lots of things that are provided by state and local government organizations, either directly or through agencies that receive funding from state and local government organizations that are covered under ADA Title II. So it's a pretty wide-reaching part of the overall Americans with Disabilities Act. And I think we've talked before about how the ADA was signed into law in 1990, and that was like less than a year after Tim Berners-Lee first conceived of the World Wide Web at the CERN Research Center in Geneva. So when the ADA was written into law, we weren't really thinking about the web as something that was a major place where people could receive those public services and programs. However, the Department of Justice has long held the position that yes, the ADA applies to the digital world. And over what 30, 35, 36 years since then, there have been several attempts to create a rule to kind of connect the ADA with the digital world. Finally, last year, the rule with this title, I had to write it down: non-discrimination on the basis of disability, accessibility of web information and services of state and local government entities. That rule was published in April 2024 and kind of came into being in June. And essentially it added a new subpart to the Title II ADA regulation, which provides some specific requirements for web content and mobile accessibility. And one of the really important things to underline is that this rule that was published last year provides additional clarity on how the ADA applies to digital world. So it wasn't a case of it changed everything. It's just here's more detail of what you need to do in order to make sure that your resources meet ADA requirements. And related to that, it doesn't reduce protection for people with disabilities where other applicable laws or regulations might already be in place to provide a higher level of protection. It's kind of almost a backstop. And that's important because there's quite a few existing state laws, local laws, and there's several in development at state level that also place accessibility requirements on covered entities in states like Colorado, New York, Virginia. There's there are already requirements that are kind of harmonized, but it's important that this provides additional technical clarity to the ADA rather than kind of extending it or changing it in a material fashion.
The way I look at it is like before this clarity came out. And if I'm right, David, like Title II of the ADA is really the first time any part of the ADA has been quite this specific in its clarity, which is really interesting because it has a direct reference to the WCAG, the WCAG guidelines and some things like that I don't think we've seen before, right? So, but the way I look at it is it's more like we've been acting as if in a large way, and this is now putting down kind of what has been going on without the clarity into sort of the clarity and the detail around what it means so that there's no more sort of like we're doing this because we think this is what we're supposed to be doing. It's like no, you're doing that and you're doing and here's some information that says correct. The way that you guys have been moving forward for the most part is what we had intended. It is correct. And like you said, even down to the point of does this apply to digital content, right? Because in 1990 it wasn't there. It wasn't until I think the mid 90s that I saw a website for the first time in my college and I didn't understand what it was.
Yeah, me too.
Meanwhile, I'm like, why? So they had like a Beavis and Butthead on this homepage that a professor had created. I'm like, I don't get it. I Beavis and Butthead's fun, but I don't get what this thing is. Meanwhile, I'm getting like AOL discs, and I'm having trouble understanding the difference between like AOL and the globe that brought you out to the web. Like it took me a while to get that concept. So it wasn't, I think, until the 2000s that we started even using the web with any extensiveness as a place of public accommodation, to your point, doing the things that we would do in buildings, physical buildings, going shopping, going to make a deposit in the bank or apply for a mortgage in a bank or any number of things like that.
Yeah, and it was a long transition from something that was a technical edge case to something that's core to providing
Yeah,
efficient public services. It's now
right. It's a complete flip.
a way to provide, save money in providing services online, providing services faster, more quickly, saving people having to travel to a facility. So there's all sorts of reasons why
In
it's become so much more important to
It
public
is.
life.
Well, and I think important's the right word, David, because it in many ways it eliminates a lot of challenges associated with having certain disabilities, right? Like getting to the bank, for example, for somebody who's blind might pose a particular challenge because, and this is before Uber and stuff like that, but if you live in a small town, like, getting a taxi, having to arrange all that, like it was quite a great deal of effort. But if you can look up your account balance by logging into your account on the web, right there, there's sort of accommodation. It's much easier unless we don't have rules around how that should be made to be accessible. So it's sort of is double frustrating if now this thing that should be making it easier is not accessible and able to be used for the individuals who probably are going to benefit the greatest from something like being able to access their banking information via the web versus having to walk into, go down into town and walk into a building or whatever the case is. So it's I think important was the right word to use.
Yeah, and that kind of that's still recognizing the existence of the digital divide, that
Mm-hmm.
technology enabled services can make them more accessible to people who have the means to access them. But the ADA isn't necessarily saying all public entities covered must now only provide services online, because
Right.
there's still that unfortunate existence of a digital divide. It's where people with lower income, people with disabilities are more likely to have limited access to tech. But when it's available, it can really help improvement. The other thing I just wanted to go back on, you were talking about how the rule had kind of provided clarity and moved us from, well, we think this is the right thing to do, to, okay, this is what the rule requires us to do. In the ADA, so often what people realized they had to do only emerged after a lawsuit and a resolution agreement
Right.
where the requirements were whatever the court told you to do or whatever you negotiated with the plaintiff in the result of a situation of digital discrimination on account of inaccessibility. So that was obviously an expensive and challenging way to get to a point where you understood what you needed to do to meet the law by sort of having been found to have broken the law. So anything that can help people stay out of court, stay away from getting lawyers involved, it's got to be a good thing. So even though a lot of the lawsuits still are related to Title III, and we're talking about Title II today, it gives us something that we can look at and say, okay, this is a DOJ position that people more broadly can look at and say, well, if it's good enough for ADA Title II, then it's probably going to help us in other situations as well. And we're not lawyers, by the way, so that is not legal advice. Just to be absolutely clear, we're technical, digital accessibility consultants and advocates, and none of this is legal advice.
Yeah, that's a good point, David. So here we are in this position where this is kind of great, right? There's been a step towards more clarity, and to your point, it's in Title II, but it's still sort of clarifying and hopeful for other aspects of the ADA. But when we're thinking about Title II specifically, and I would imagine a lot of people who've tuned into this podcast are like, okay, let's talk to me about Title II because that's what we're here, that's what we're concerned about. We're a state entity, for example. There's a couple of deadlines that are really important, and we kind of were joking around at the top of the episode about is it an anniversary if it's something like a deadline coming up in a year. So talk to me about those deadlines because there is a deadline coming up. Both of them are April 24th. The first deadline is 2026 and the second deadline is 2027. So what are we looking at with those two deadlines?
Right. So the 2026 deadline is for organizations that have populations of 50,000 people or more. So given that the EDA Title II applies to state and local government entities, they kind of serve a defined geographical or administrative area, and based on the population that's served, that defines the deadline by which you need to meet the accessibility requirements. And that the logic there to have those two deadlines was smaller state or local government entities are probably less well equipped to remediate their digital resources quickly compared to a larger organization. We can the rule went through a lot of public review, internal revision, so the logic has been tested, and that's what they came up with. And it does give everyone a bit of time. That's just over a year for the larger organizations, but that was essentially the driver behind having two deadlines. Recognizing that smaller entities may have more limited resources in terms of personnel or budget to address, take the necessary steps to meet the requirements.
Got it. And so 2027 is really the same requirement.
Yeah.
But for those organizations that are smaller, that are less than 50,000 people, that
Right.
makes total sense. So, we've talked about this wonderful clarity that we have now and what an important step that is. What does that mean for technical requirements for the rule?
So the rule applies to web content and mobile apps. And web content means HTML web pages, including embedded audio and video, and web applications as well. Also, digital documents are what the ADA Title II rule refers to: conventional electronic documents. I'm not sure what an unconventional electronic document is, but never mind. So we're talking about things like Word documents, PowerPoint, PDFs, that kind of thing. Familiar formats that are used to provide information as part of a public program or service provided by a public entity. So that's what the rule specifically addresses. And in terms of the technical requirement, it requires those covered digital entities to meet WCAG level AA, WCAG 2.1 level AA. So this is an interesting point of conversation because we are currently at level 2.2 of the Web Content Accessibility Guidelines. However, the rule was published after WCAG 2.2 was published, but still refers to level 2.1 or version 2.1, essentially because the Department of Justice felt that WCAG 2.2 was still too recent for people to be familiar with enough to be able to adopt it. Again,
That's not, it's not stopping anybody from doing 2.2.
Absolutely. That's a really important point. It doesn't mean that you're not allowed to meet 2.2. It just means that the minimum requirement is 2.1 level AA. And
as we move from one version to the next, it tends to be an additive process. So meeting
right.
0.2 is a step beyond meeting 2.1. It's not like an instead of that might get you in some trouble. You're meeting 2.1 and then a few additional items that are included in 2.2.
Yeah.
Is that right?
Yeah.
Okay.
Yeah. So yeah, and one of the really good things about the way that the Department of Justice does its rulemaking process is that there's a lot of published information about how they responded to feedback on the proposed rule or the draft rule. They draft a rule, they put it out for public comment, and then when they publish the final rule, they talk about how they reacted to the feedback they received. And the when they issued the notice of proposed rulemaking, essentially the draft rule, there were some things in there that aren't in the final rule, and people said, no, this is not a good idea. Some of the exemptions that we'll talk about, or some of the exemptions that didn't make it, that were removed from the final rule, people said this is not a good idea to have these as exemptions, particularly things relating to educational content. But all of that discussion is publicly available, so you can go and read why the Department of Justice might have said. Some people said we should change it to be the latest version of WCAG, and the reply was, can't do that. We have to reference a specific standard. We can't reference
Right.
something kind of obliquely, say whichever the latest version is, because there's that they're just not allowed to do that. So that's why they had to reference a specific version of WCAG. So it means it's not future proofed, and that the rule would have to be updated if, and let's say WCAG 3 came out, then the rule would have to be updated to adopt WCAG 3 as a standard, and that can lead to problems. We've seen that before, where rules and laws reference a version of WCAG that was then replaced, and then that rule still references an old version. But back to your point, there's nothing to stop you going above and beyond. But I appreciate
you as an
that.
organization are essentially making a decision to future proof yourself in air quotes there by
Yeah.
doing that. It's
Yeah.
making an assumption that at some point a ruling like this is going to be updated and it's going to go to it's going to reference a more recent version, right? Maybe 2.2
Yeah.
is referenced when 3.0 comes out or something like that. But you can count on some pace of moving into future versions of the guidelines. You mentioned the exemptions, right? So what about the exemptions, right? ADA has longstanding exemptions, fundamental alterations, and undue burden, right? Um, which apply to the web and mobile rule, but you've got to, I guess, be careful about how you use those and interpret those. What what do you have to think about when it comes to that, and what other exemptions should we be aware of?
Yeah, so that fundamental alteration and undue burden are two kind of core principles of the ADA and other disability law. So the European Accessibility Act has something very similar. And it's essentially saying that if in implementing the accessibility requirements, you would materially change the functionality or the purpose of whatever it is you're trying to make accessible, then you don't have to do it. You know, that it stops people interpreting the requirements in a way that is really changes the purpose of the service or the program or whatever it is they're trying to make accessible. And it helps direct efforts where they're going to have the most positive impact on people with disabilities. The undue burden one is where an organization might say, we want to meet the requirements, but it's going to cost us so much, or administratively, it's going to require such a burden on us that we don't think we can justify that effort. And again, that's okay. It's saying that where it's recognizing that resources are not unlimited and directing those resources to where they have most positive impact on people with disabilities and where you're not wasting effort trying to make something accessible that may be difficult or impossible to do. So it just, they're two principles that help guide efforts where they have most positive impact. And they also apply to the digital assets covered by the Title II rule. It's probably less, compared to trying to change a building that's built 200 years ago to try and make it accessible versus updating a website, remediating a website to remove accessibility barriers. In the vast majority of cases, fixing digital stuff is easier than trying to renovate an old castle or something to make it accessible. So these exemptions are probably less applicable in the digital world, but there will be cases where it's because of the nature of the digital resource or just how it was built, that it may well be just really, really difficult.
I remember back in the Flash days, that was when there was just certain things written in Flash that were next to impossible to make accessible, and the answer was, well, you need to rewrite this and something more accessible, which I think HTML5 came about and a few other things came about where that was possible. But the idea that you would have to rip out an entire aspect of your code base and rewrite it, could cause problems. I also think like people must be listening to this and thinking, okay, that's great, but how do I really know I fall under like fundamental alteration or undue burden, right? Undue burden doesn't mean like it's a little hard. It means it's gonna break something, or it may kind of sink the ship, or there's a big deal here. And fundamental alteration doesn't mean that things won't change slightly. It means that they change fundamentally. So how do you make those judgments? And I think this is another, we're not lawyers, right? Situation.
Exactly.
Like we can make you aware of this, but this is really for your counsel to make a judgment on in terms of whether or not something might be undue burden or fundamental alteration, and it's up to them to make that call and be confident that they can defend it and all that kind of stuff. So if you're wondering how you navigate those exemptions, that's how you navigate those exemptions, in my opinion, is working with counsel to make sure that you're looking to them for their interpretation of it and whether or not.
Exactly. Yeah. And the ADA has specific definitions of what those exemption situations are and what evidence you'd need to provide. And essentially it's like, do you want to fix stuff, or do you want to engage lawyers in trying to defend why you shouldn't fix stuff? Usually fixing stuff is the better way to go. And it's certainly the better way to go for people with disabilities. But yeah, there are some specific types of digital content that the rule has exemptions for. So archived web content, and there's a specific definition of what archived means, but essentially something that's was created in the past and is labeled as an archive, and something that's generally not going to be changed, and it's kind of old records or whatever. Pre-existing digital documents, those conventional electronic documents we talked about.
Yeah, I wouldn't just stay on archive web content and give you an example and just to see if I'm following that right. Like oftentimes what I see is a lot of organizations will come to us and they have a whole bunch of PDFs that need to be made accessible. But when you look across those PDFs, first of all, there's probably some of them that they can sort of get rid of that don't even need to be archived. But to the point that you made, there's a lot of them that somebody may want to go back and reference for some reason at some point, but they're no longer currently relevant. Like they were intended for a time in the past. Like think of an annual report, that's
Hmm.
years old or something like that. Um, and so those can go into like an archive versus being kind of out on the public website or wherever they're stored as current material. Would that be considered archived web content in that case? Is that
It sounds like it, yes, if it's stored in a part of the website that's clearly identified as an archive
okay?
of content. And something you said there is, when it emphasized that it's that if somebody wants to access that content and they have accessibility needs, you still have an obligation to provide the content in an accessible format under the ADA. It's just that the rule in web and mobile app accessibility has those exemptions, but
Hmm.
the ADA itself doesn't mean that you can say, no, we're not going to provide you with that information. You still have to provide, uh, you know, provide that information when somebody asks for it in an accessible format. And it might be an alternative
You may not
version.
fix all
So
of those piles and piles of in this example documents, but when somebody says, "Hey, yeah, I do want to look at that," 2020 annual report at that and I have I use a screen reader to access content now you might need to go back and look at that 2020 annual report and make
right.
it accessible. Okay,
Yeah.
that makes
So
sense.
and these exemptions are all about, again, avoiding organizations that are covered under Title II to spend all their time focusing on stuff that people are less likely to
Mhm.
need to access compared to, let's say, the state website or something that is a higher priority. So it's all about focusing efforts first on the most high priority stuff, and then that's where the list of exempted content and just to complete that list that included content posted by a third party that isn't engaged by the public entity to provide content. So, for example, a comment provided in a news article or a social media post that wouldn't be covered by the rule. Individualized password protected content, which is a bit more controversial because that could be something like a health record, which is really important for somebody to access in an accessible way, but nevertheless, that was included in the list of exemptions and pre-existing social media content posted by a public entity. So the rule is essentially saying that you don't have to go back and remediate all your Facebook posts from 2015,
Right.
2016. But if somebody wanted to read it and said this is an important part of the service you're providing, then would be obliged to
You
to
might have to
to
do it in
to,
that
to
case.
help them, but it's not something that you need to prioritize. And again, it's sort of focusing efforts and where there's highest priority.
So, and then that's good news. Like people have been posting on Facebook and other things for a long time, so having to go back and make all and also they're done by sometimes by third party people or people are not around, like the
Mm,
difficulty around
mm,
that it would be high, I would imagine. So some of the other exemptions, so one of them talks about like an alternative version, right? So when a conforming alternative version, according to the way that WCAG defined it, is available instead of a single version that conforms to WCAG 2.0, 2.1, I'm sorry, at level AA. So in other words, it's okay under Title III of the ADA to have an alternative version out there that is conforming to the guidelines. You don't necessarily have to make that, we'll call it the existing version or a single version, both usable by people without disabilities and people with disabilities. Is that what that is saying?
mm.
Ish.
In very, very
Struggle with this one, to be
specific,
honest with you.
Yeah, in
Yeah.
very specific circumstances, it's it's one of these things that in the vast majority of cases, remediating a single version of a website or app to be
Mhm.
conformant is the required and appropriate way to go. But there may be specific situations where it's just not technically possible to meet the accessibility requirements, then you can provide a conforming alternative version. But again, this is not to be seen as an easy get out clause to avoid remediating a website. It's in very specific, rare circumstances that this exemption might apply. And similarly, the other exemption where non-conformance with WCAG does not materially affect access to content, functionality, or participation for people with disabilities. This one might be a little bit more common where you might be able to argue that the existence of a of where you don't meet WCAG, let's say there's a decorative image missing an alt attribute in the footer of a web page. Yeah, technically it's non-conformant, but does it stop anybody from accessing information or functionality or being able to perform tasks? If it doesn't, then you might be able to say, well, we can claim that exemption. So
So,
that
so
that
let's not get too picky about this. The spirit is that folks need access to this content. So
right,
we don't want to beat people up over little, which I think is important, right? Because websites, mobile application, all these things, they have bugs anyways, right? That affect everyone.
yeah, yeah,
And sometimes an accessibility issue is a bug that's affecting people with disabilities, but if people are still able to access, do we really want to punish somebody too deeply for that? Or is it just like, oh yeah, well, let's go fix this like we would fix any other bug or whatever the case is, or maybe we don't need to for some reason. But
yeah.
but I kind of like it because it says, yes, the guidelines are important, but let's remember that they're guidelines. What's really important here is this concept of everybody being able to access the content.
Yeah, and it kind of recognizes that not all accessibility bugs are equal. For a given success criteria, even at level A, the severity of the issue in terms of its impact on people with disabilities might might vary depending on where the issue is in a website, in a workflow,
Yeah.
or task flow. So again, we're not saying that this is a license to just ignore a bunch of issues you think are not important, but more prioritize the ones that impede or prevent people from being able to do stuff, and then the ones that it's
Yeah.
clear from where they are on the web page or in the app that they're unlikely to have any material impact, then they become lower
Prioritize something
priority.
else
Yeah,
that does have a
yeah,
material impact. Yeah.
right. Yeah,
So David, we're actually coming up on the half hour, which is sort of our unspoken time frame for these podcasts is 30 minutes. There's a ton more that we could talk about here, right? And we just don't, there's never enough time. So is there anything like really important in the next minute or two that you think we should bring across before we kind of wrap things up?
well, I think it's worth just noting. I feel like we're going to have to come back and talk again about the strategy to implement with for organizations to adopt to be ready to meet the deadline. And this is it's a strategy that we are familiar with more broadly as an approach to take to improve accessibility of your digital assets.
Mhm.
But I did want to mention that we've been talking about ADA's applicability to public entities, and it's public entities that are on the hook to meet these requirements. But private organizations who have public entities as customers of their digital
That's
products, tools, services may think, well, we don't need to worry about this. But as a supplier to a public entity that's subject to ADA Title II's requirements, you have an opportunity to help your customer meet their obligations by providing tools and services that also meet WCAG 2.1 AA. And even though the law might not apply to you, uh, you can go a long way to making your products and services more attractive to public entities
That's a good point.
by showing evidence that they meet the Title II requirements. And if you don't do it, somebody else is going to be doing it. So, even if you're a private entity and you think, I don't need to worry about this, there's an opportunity there for you. And I know that there's had one of the criticisms of the Title II rule is that it puts all of the responsibility on the public entities and not on their partners, their vendors. And I guess we're kind of relying on market forces to encourage the vendors to do a little bit more than maybe they've been doing so far to help entities meet their requirements.
Yeah, that's a really good point, right? Don't just think if you have to be a public entity for this to have an effect. That
Exactly. Yeah.
Public entities think about that as well. All right.
So yeah, I think we with just over 1 year until the first deadline for organizations that are covered by ADA Title II, there's definitely still time to prepare and still time for us to talk more, maybe in an upcoming podcast. I know it's not going to be the next one because we've got a special guest talking about a trip to Antarctica. I believe so. Looking forward to that one.
Yeah, that'll be a good one.
Yeah.
Great discussion, David. And I think you're right. There's still time to prepare, but I also think you should probably start preparing right now. Like a year is not as long as you might think to start addressing these things and get where you're going to need to be to hit that first deadline if you're over 50,000 employees. Well, now you know the state of accessibility. I am Mark Miller, thinking David Sloan, and reminding you that the state of accessibility is always changing. So please help us affect change.